glad to see everyone's still awake for our legal panel. Very exciting. Thank you so much for joining Moustafa and Khaled and I this morning to discuss legal issues associated with branded residences. Now, I have had the pleasure of working on hotel and branded residence projects for a very long time. I'm not going to say how long, but a long time. And I've had the pleasure of working on projects from Australia, across Asia, Middle East, Europe, and the Americas, which actually puts me in a good position for this panel. I've also been doing most of this work for operators, which when I look at my fellow panelists, when we were preparing for today's session, there was a lot of discussion around importance for owners. So you might hear me occasionally kick it in for the operators to make sure that we are protected and presented here today as well. So firstly, we have obviously Moustafa from Wisefields, who I'll ask him to introduce himself. We've had the pleasure of working across the table and sometimes beside the table from time to time, but Wisefields has a wonderful reputation as an expert firm in hospitality and branded residences. And Khaled, of course, who I've also had the pleasure of working across the table from, working on hospitality projects, working for Baker and McKenzie, one of the preeminent hospitality firms. I know they do other things, but for us, they're a hotels firm. So why don't you guys say a little bit about yourself, and thank you for joining me today.
Thank you, Rhonda. Thank you for your kind words as well. So my name's Moustafa Zowayed. I've been in the region almost 20 years now. My colleague Bilal Kapafi and I set up Wisefields about 2.5 years ago, and previously at other leading firms in the region, but we really set it up as a real estate and hospitality focused firm.
That's a very humble intro from you, Moustafa. There's more you should be saying, but thank you all for being here, and thanks for the intro, Rhonda. As you mentioned, I think we both hospitality lawyers, all three hospitality lawyers, and been focusing on hotels, branded residences, franchise for a while now. Yeah, very excited about this panel, if you can be excited about legal panels.
Of course you can. Come on, we're all excited today, aren't we? Please? Excellent, thank you. The check's at the door. Okay, so let's get cracking. We've got 30 minutes, so I want to try and make this interesting for everybody and also informative. So I've got a couple of questions for the panel, and then we'll open the floor up to any questions from you guys. Now, the first question, Moustafa, branded residences, easy to do, easy to structure, not too many documents?
You could say that, or there's probably quite a lot of documents. Certainly, in my experience, every brand has their own templates, their own preferred manner of doing things, but generally speaking, there's some uniform trends across the industry. Typically the brand would have a sales and marketing license agreement, so that will set out the intellectual property license of the brand. It covers the sales and marketing period, but it has a lot of conditions attached, as you would expect. The brand has to approve all the marketing collateral, has to approve the sales and governing documents, has a lot of restrictions around short-term lettings, around rental programs, guaranteed returns, whether they're permitted or not permitted. There's also typically a technical services agreement that the brand effectively works in conjunction with the developer and the developer's consultants to agree on the technical specifications, the area program, the furniture and equipment, the operating supplies and equipment, and really map out a construction deadline, a roadmap for completing the project, scheduled visits that the brand would have. And the other important consideration is also, to Rico's point earlier in the previous panel, what happens when the glamour is gone? How is this project going to be operated? How do we make sure that we, as the owner of the brand, can enforce brand standards? So making sure that the legal framework supports the implementation of the brand standards, and that these are then clearly disclosed to purchasers, because purchasers, whether or not they read their SPAs, if they sign up to it, then they're deemed to have accepted those positions.
And I guess the skeleton, we talked about it, governing documents. Right? They're the documents that the owners have to spend a lot of time working through to make sure that they comply with local requirements. What sort of things are you seeing that form part of the governing documents as well?
So governing documents, the starting point is for an unbranded building. It has to do with either a homeowner association like there would be in Saudi, is it a building manager like there is in Dubai, for example, how provisions around the budget, provisions around having committees. Typically there's provisions around the imposition of service charges. You have an operating service charge as well as a sinking fund to ensure that there's sufficient reserves available for capital maintenance of the building. So all of those apply whether or not the building is branded. And then you have this overlay that's applied on top that has the brand specific requirements. It typically would involve the continued effectiveness of the licensing agreements and the operating agreements with the brand. It requires typically the brand company would have an ongoing facilitating role in supporting the delivery of certain services that are required to maintain the building to brand standards. That necessitates a higher level of service charges. If it's a co-located project, then you need to map out the access to the shared amenities of the hotel, and of course that also then necessitates a contribution towards the ongoing cost of operating and maintaining those shared facilities. And they would all apply mandatorily, whether or not I as an individual apartment owner avail myself of those services, it doesn't matter. I'm purchasing an interest in the scheme and I'm bound by the rules of that scheme.
Just to add on the governing documents, I think ultimately what you're trying to do in these governing documents is to ensure that the project from beginning until the end of the life cycle remains as a hotel, right? Because however we divide it up, however differently we might look at the branded residences project, ultimately it's a hotel, and we want to ensure that it's managed and maintained like a hotel throughout its life. And I think part of the challenges that we have with some of the regulations is that a lot of the subdivision regulations we have were designed for an apartment building where there's a single owner association to manage very simple common areas without being able to bake into it, let's say, a operator that's supposed to stay for the life cycle of the project. There is a new draft law in the kingdom that's circulating in relation to subdivision, probably issued about a week or so we're still not into its details, and it's just an early draft form. Maybe that can help bring the regulations more in line with certain jurisdictions where you can have special management schemes, have the developer maintain control of common areas, all kind of important and can help give more regulation to the relationship as opposed to trying to do everything in the bylaws and it being subject to change by the majority of owners in the future.
Yeah, and those governing documents, the structure of those and complying with the local requirements, it really is in the hands of both the brand as well as the developer, because we are putting together a project that we need to be able to sell in the market. So they're not just one-sided for the developer or one-sided for the brand. We also have to be future-looking. And I think you make an interesting point around it being a hotel. When we look at standalone residents as well, we're also looking at how that brand DNA, we've heard the last panel talk about how we maintain that so that it still stays with, I think, the Tajness, I really like that word, but how that continues to the brand DNA, the brand essence continues. But it is a complicated structure. There are a lot of documents, and it's why we work with specialised advisors, whether it's accounting and legal as well. But Khaled, there's a lot of pain points, I guess, in some of the negotiations, some of the issues that you're seeing come up again. What sort of things would you talk to this audience about?
I would say, the pain points are probably the ones that are, the hardest to negotiate. Otherwise, we wouldn't have called them pain points. And because they're so important to the operator from a certain perspective, yet also important to developers and owners. And I think, from an operator's perspective, I think there's probably 2 or 3 main concerns. Obviously the protection of the brand remains the number one concern, I would think, in addition to the quality of service, which all feeds into protecting the brand. So I think indemnity provisions become very important. In this part of the world, we used to not spend a lot of time negotiating indemnity provisions because they were not very easily enforceable. I think with changes in laws now, they're more likely to be enforceable than not. So a lot of attention is going into it, but I think, for many operators, it's a non-negotiable, or you can negotiate very little. You can just maybe water them down a little. But it's the concept of, the operator at the end does not want to be responsible for anything that goes wrong, whether it's in the construction, in the sales or anything moving forward. The owner remains the owner of the project and ultimately liable for anything that could occur. Other than that, I think we see a lot of back and forth when it comes to use of deposits and having perhaps reserves or construction reserves, and I think operators are very keen, and I'm sure you will also point out that it's, you're keen about those provisions not just to protect yourselves but also to protect the project and it being able to be completed. In some jurisdictions, let's say the real estate governing or regulatory authority has strict provisions already, but sometimes you do have to be effectively an extra regulator to make sure that these aren't misused. And then from an owner's perspective, I think one of the main challenges we find is effectively the back-to-back arrangements that have to be put in place, because ultimately the operator does not want to take the risk associated with shortfalls in service charge, capital expenditure, and what might happen to the project in the future. And it's easier to accept when it's part of a hotel that the owner/developer is, signs the owner, because the owner-developer would usually sign the management agreement with the owners association and owners to manage the property, yet they'll effectively subcontract the management services to the operator. So there's a back-to-back arrangement whereby the owner is the face and liable vis-a-vis the unit buyers. And that can create challenges for some owners, because especially if it's a standalone project, a lot of owners want to build, sell, and exit. But I think we still haven't reached the point in the market, especially with the big operators, where they accept the concept of dealing with the owner association for the full life cycle of the project, or to have a direct management agreement with them. A few operators actually prefer that, because they do want to be directly involved even in the owner association management, but most operators, we still see putting in place the back-to-back arrangement, which owners, have to come to comfort with, I'd say.
Yeah, I mean, from my perspective as well, it's if I can talk the experience in Dubai, the law allows, in fact, it contemplates that hotel operators will become building managers, effectively the equivalent of an association manager. But generally speaking, the industry, not talking about any one or two operators, the industry has said no, we would prefer the owner to retain that function, or we would want the building manager to be someone we approve, but not us. So certainly there's an opportunity for, as an industry, for hotel management companies to step into that category as well.
Yeah, I think it will be interesting to see how we continue to evolve and where the opportunities are. I think that branded residential started in the US, and there's a lot of litigation in the US. Apologies to those of you who are American, but there's a lot of litigation in the US, and therefore sometimes I think historically the operators have been a little nervous about that, because at the end of the day the brand is on the top of the building. But you made an interesting point, Khaled, around standalone, and I think that one of the things that the brand is focused on when it comes to standalone is, I think someone mentioned it yesterday, selling a handbag. I think we're trying to sell a little bit more than a handbag. A fake handbag. I was trying to be nice, okay, Certainly standalone is from an operator perspective, and I think from the owner developers out there, it's more than that. We're trying to create a DNA and essence of vibe. We're selling to a certain type of person, not plugging at all, but we're talking about a project with 25 hours high mat in Dubai. And for those of you who know that project, the hotel in Dubai, the residential project standalone that's being built is very unique. It's very focused on creating the same vibe, the same guest amenities, and creating something new and different, which is where I think standalone will go. I think they'll be real handbags, shall we say, with more than just the bag. Excellent. Okay, so we're going to talk next a little bit about sales. So we've structured the buildings, we've got an agreement with the operators, and now we actually have to make some money, both the owner developer and the brand. So that means we have to sell. We have to find buyers out there who are willing to buy. Now, I might work out which of the two of you or both you will get Daniel's hospital pass around securities, but we'll come back to that one. Moustafa, where are you focusing on looking at how to sell these projects and how to sell them to the consumer? When you're looking at the documents you're drafting, the legal restrictions, what sort of things do you think are important for an owner developer to be focused on?
So I think, certainly if we talk in the Saudi context, it's a heavily regulated industry. WAFI is the local regulator. There's a form of sale and purchase agreement that must be used. There's pretty strict compliance with that form of document. In previous years, you were able to use your own form of document as long as it was in general harmony or sympathy with that document, but they've now moved towards using a baseline document that's shared by the industry. So I think, really put in is that the law does prescribe certain information that must be provided, but I think, which applies to unbranded residences anyway, but I think really the purpose is to put as much information and to be as clear as you can possibly be about the intended management framework, the area that's being sold, the basis on which the role of the brand, and also the first question I always ask is, what does the brand mean? Is it just a sign at the front of the door, or do I get access to an adjacent hotel? Do I get access to a loyalty program? What is the basis on which I can access the facilities of the hotel? Short-term letting restrictions, typically the brand would say we don't want, even on a standalone building, to operate like a hotel. We want to preserve its character as a residential, albeit a branded residential product. So there's often restrictions around short-term letting, Airbnb, those types of arrangements. If there is a rental program, it's very important to clearly set out the contours of that rental program. Is it a pooled versus non-pooled scheme? Are there guaranteed returns or variable returns? Is it a top-line structure? In other words, do you get just a flat percentage of the room revenue, or is it a bottom line, which means you just get a proportion of the operating profit of that scheme? So all of those need to be adequately set out in the sale and purchase agreement. I always recommend attaching the governing documents to avoid that's not strictly a legal requirement either in the UAE or in Saudi, but it's something that we would highly recommend, together with a disclosure statement that sets out all the relevant requirements. But and typically the brand would have a form of acknowledgement that says, we are not the developer, we are not the entity that's selling. You understand and appreciate that we're a licensor, and we can remove the brand at any time. And obviously, if there's a default in terms of the agreements with the brand, so it doesn't stop owners wanting to sue the brand, of course. But at least, if you have that written undertaking or acknowledgement, then at least you have that starting point of saying, look, you have a direct contractual relationship with the developer, not with us. We're just a licensor, and our arrangements are with the developer directly.
I guess as part of the structure, what we're trying to do is future-proof potential unhappy future owners of the building, whether it's for the owner-developer or for the brand, or even just for the community within which the people live in that building. Khaled, we were talking earlier about sort of shared amenities and that combination, I think, which we didn't talk about, but the combination of rental programs. It's why operators insist on not having an Airbnb process as part of the residential program, so that we don't have parties in the room next door when you're trying to rock your 6-month-old baby to sleep because you live in the apartment next door. What sort of other issues are you seeing, or you have seen or could see in this space?
Yeah, I think, to break down the issues or the common points of discussion, let's say, when we're sitting on the negotiating table, let's say, and some points will be simple for many of the audience, but just to cover, let's say, the main 5 or 6 points we usually discuss. I think, ultimately the documents do look and feel like hotel management contracts, with the added sale element and owner association element, if you can break that down. And perhaps with the sale element, there's the fee associated with the sales, and being clear on when and how that fee is paid, whether it's paid, as soon as the payment is made, or whether it's paid on closing, or whether it's paid when the full sale price is achieved. I think is usually an important one for developers. Other things to keep in mind are, when it comes to approval of documentation and pricing from the operator. I think from an owner's perspective, we always acknowledge that there's a certain quality control and added value from the operator reviewing the set of documents that but you usually go through a process of preparing the documents based on Riga now looks after the off-plan, let's say, sale requirements, localizing the documents, ensuring they cover all of the operator's requirements, and then sharing the set with the operator, and you're hoping at that stage, you don't get any change of direction or any kind of heavy comments on the set. And I think that's understandable that these need to be reviewed. Perhaps where it becomes a bit more sensitive is where prices need to be agreed as well with the operator sometimes, and if you agree a floor for prices, and sometimes, in an ideal world where you sell everything and it doesn't take a lot of time for the full inventory to be sold, probably less of an issue, but sometimes you do maybe need to go below certain expected prices to sell, and owners like to have that flexibility because at the end, it's shared interest at the end, let's say, in relation to selling. Other important points we see relate to perhaps management of the owners association is always important. We see different operators try to do it differently sometimes to have an extra level of control over the owners association, whether it's having certain retained units or certain retained amenities within the hotel to ensure that the developer is still invested or kind of still has a foot in the project. We also see sometimes the use of powers of attorney to help with certain voting, but we think the regulations here don't really allow for that because you can't have majority control over an association and the use of powers of attorney is seen through in a way, and you can't give up your voting right. I think other important points are also thinking about what's going to happen to any unsold inventory. Can you lease them? What's the shortest term of lease? How is that going to work? Is it going to go back into the hotel inventory, or are they leased on long-term leases, etc.? And I think from a developer's perspective, it's important to just be able to monetize them without obviously damaging the brand or damaging if there's a hotel connected or associated with it. Rental pool is also always a subject of discussion if it's being offered. I think from brand to brand, depending on location, rental pools can work well, and sometimes they don't work well. And I think for many of the US operators, it's more a rental, let's say, program than a pool to avoid triggering any securities laws, etc. But also there's a lot that goes with it in terms of what's the minimum term you have to put your unit into a rental pool, what's the minimum number of units that need to be in a rental pool for it to be a rental pool. And I think what's important or what's worth mentioning is that we really do see operators take almost very different approaches to these points. You have some that would have a very fixed number or percentage of rental pool. You have some where as long as the hotel is standalone or there's a hotel next by the next number of rooms, as long as you give them advance notice for them to be able to budget, etc. for the following year, that they really don't mind and meet the FF&E requirements, then that there's more flexibility on that. I think those are the main points. Obviously, I touched on indemnities. That's always a point that's discussed more so nowadays than in the past. I think I've covered the main points we negotiate. I don't know, Moustafa, or if there's anything you think worth covering.
Yeah, I think a couple of trends that I'm noticing is a move also towards franchise residential. So, we say that in hotel space, there's where effectively the hotel brand is not managing the hotel, it's just granting the rights to the use of the brand. And we're seeing that in a standalone residential. And another sort of trend I'm seeing as well is for those developers that are building and have the strategy of really building and selling and getting out of there and trying to address the gap with the operator that wants someone to be on board for a more permanent period of time. We are seeing white label operators coming to the market and offering to perform that function really on the developer's behalf. So that's sort of the evolution of trends that I'm noticing in the last couple of years and will likely to accelerate in the future as well.
Yes, franchise residential, something we need to watch and something I do think we need to be careful about, selling an empty handbag, Daniel. Look, I think it's really interesting when we see the evolution of where branded residential has come, some of the complexity. When we're putting together these structures, when we're drafting and preparing the documents, we do have to look at the owner developers' needs and requirements, the operator's needs and requirements, but also of the future buyer and the person who's going to live in those residences. And I think it's really interesting when you're sitting at the table negotiating these documents, if you have somebody from your operations team or your brand residences team or your selling team, not in every conversation, because they don't need to be there for the indemnities debate, but for part of the conversation, because it's really important to be future-proofing your project and thinking about the different issues. We've been having a discussion recently on something about branded residential with a hotel, and how many residences there are versus how many hotel rooms, and if I'm a guest, can I still get a sunbed by the pool? Or can I get breakfast? Can I use the gym? If I'm a resident, I'm going to want those things, and if I'm a guest, I'm going to want those things. And so you have to kind of find ways to manage. I think we've done pretty well in terms of timing. Throw it open to questions if there are any. Yes? Done it?
Sanjeev, I think, yeah.
Thank you, everyone. The question I will ask, it has no definitive answer, I know that, but I still like to have your views. Generally, when it comes to the branded residence, the service charge sometimes comes from the developer sides. So I would like to know, what is the law, bylaw, or what is the standard in the market you guys observe, that out of that, how much portion is from the brand and operator?
I'm not sure I understand the question.
The question is, when you have a branded residence service charges, out of that service charges, how much exactly the operator charges, and what is the benchmark? Is there any bylaws for that?
For us as lawyers, we're probably not the best to answer that question, but from what I hear, it's usually above 50%, and there's always discussion as to whether the regulators will have concern that a big part of the service charge that's being collected by the Oral Association is being paid for the manager's fees effectively. I'm yet to come across any regulations that restrict that, but I don't know if anyone has.
Yeah, I mean, I think from the fee component has the operating fees in branded residential context is typically a percentage of the operating budget. Sometimes there'll be a floor price per number of units. You know, if it's a villa or an apartment, it might be an agreed price. And typically there'll be an escalation for inflation. So it's not just an amount that's agreed in year one. There's normally a progression for inflation. But typically you're looking at 8, 10, 12% of the budget is what the manager would. I have seen higher, I've seen lower, but that's sort of the market standard, I would say.
And probably I think one of the best thing in relation to this is what you touched on is in the sales documentation. The most important is to fully disclose all the details, right? I think that's your best protection to avoid being seen to have tricked any of the buyers or not to have been transparent on what fees are actually being charged and what you've signed up to as a developer.
Any other questions?
Last question, I'm so sorry.
Thank you, Khaled and Moustafa. I'm happy to see Rhonda shining on this beautiful panel again. So my question is regarding the Saudi Arabia regulations. If there's any regulation regarding the branded residence yet out or it's in preparation. Secondly, what about the shared spaces area, where there is a hotel and there are spaces where on the same building, is it owned by the developer or the buyer?
Yeah, so I'm not aware of any specific branded residences. Certainly, WAFI takes the view that a real estate sale is bricks and mortar, and they generally take a less active interest in, if I can call it, brand provisions. In terms of common area, the law is very clear on this point that you can have common area that's allocated exclusively to one user or to a category of users. So in a shared building where you might have the hotel on the ground, on the ground floor and the residences sitting on level 20 and above, you could have common areas that are unique to the hotel. You could have common areas that are unique to the residence. It could be a residence lounge. and you could have a common area that's common to both, so it could be the lift structure, the lift core, etc. And so the law allows you to categorise different common areas according to the benefiting use. So that's how you address that point.
And also just to break down the regulations, I would say branded residences doesn't usually have its own regulation just for branded residences, but it's probably 2 or 3 regulated areas that come together. So let's say off-plan sale regulations would be applicable because you're selling units off-plan most of the time. Owners associations regulations and subdivision, fraction ownership, let's say. So those 2 laws are usually the most relevant and important ones, along with your general, sale of real estate or real estate ownership related laws, etc. Titling, and also on the common areas point, I think at least the draft new law does allow for each kind of common area to have, the title per unit owner has to have the percentage share you have of the overall land and of certain common areas. So there is certain concepts that allow for, dividing up the ownership of common areas accordingly.
Thank you, and thank you, panel. It's been great chatting to you. I had a good morning session this morning, and I hope you enjoyed our legal panel. I hope you were able to take something away of interest, and remember, indemnities are exciting. Thank you so much.